The Supreme Court ended this systemic use of race as a factor in college admissions on Thursday. According to Harvard, which is one of the schools involved in the litigation, more than 40% of universities consider race to some degree. The justices were split along ideological lines. For more on this, let's bring in Jess Bravin. He's a Supreme Court correspondent for the Wall Street Journal. Jess, let's just start with the easy part. Explain the court's decision to overturn affirmative action.
Sure. This was a 6-3 decision. The conservatives, led by Chief Justice John Roberts, found that it violates equal protection to consider race in college admissions, that there are very, very few times that the Constitution permits government agencies or entities that receive government funds from discriminating based on race, and diversity in college admissions no longer qualified. There were 3 dissenters, the liberals, who felt who took a very different view of what equality means under the Constitution. And we heard actually about 50 minutes of justices reading their opinions today, showing how seriously they took this issue.
As I understand it, the court had previously held in a previous ruling, I think from 2003, that the Equal Protection Clause of the 14th Amendment did allow the use of race in university admission plans because there was this compelling interest. So is the new ruling that the court's previous view was wrong, or that the court's previous rule no longer holds because American society has moved on?
Chief Justice Roberts didn't exactly clarify that temporal question, but we know that he's never been a fan of any kind of racial preferences. And had he been on the court during earlier cases, he would have voted against them. In fact, he has voted against them in earlier cases. But whatever the rule was previously, it's no longer good. You're right. It goes back actually to 1978 in a case called Bakke, where the Supreme Court said that race could be used as a plus factor, not for quotas, or you couldn't have a separate track for minority admissions, but it could enter the mix of things like where you're from, or whether you play an instrument, or whether your parents went to Harvard, things like that, that the university could consider, and race could be a plus factor. Why? Not the student's right, the university's right. It's First Amendment right under academic freedom to create the kind of learning environment it wants. That is no longer the case. The Supreme Court said today that it's just too vague. It's not concrete. There's no way to evaluate when that goal is ever met. And it's time to end any kind of racial preferences, even for benign reasons, even if well-intentioned, the Chief Justice said.
You mentioned that the justices read from the bench. Justice Sotomayor wrote in her dissent, that the court was, quote, further entrenching racial inequality in education with its ruling. Was the back and forth and this reading from the bench, give us a sense of, was that particularly heated? Is that particularly out of place normally? Give us a sense of the kind of arguments firing back and forth between the two sides.
You know, it's not heated like you might find at a debate or something like that. But, the court has a kind of kabuki theater-like language where the justices can signal how seriously they take something, how concerned they are. The person who writes a majority opinion usually reads a summary of it. Here, the Chief Justice read a great deal of his opinion. Justice Clarence Thomas then read from his own very long concurring opinion about the use of race in admissions. And then Justice Sonia Sotomayor read for the longest period, almost half an hour, from her dissenting opinion. And when a justice reads a concurring opinion or a dissenting opinion, that's a signal that they take it very, very seriously. No other dissents have been read from the bench this term. So that's a message to the world that the losers are very, very unhappy with the decision and think that the majority was profoundly wrong. So that's the feeling there. But they're not throwing brickbats at each other. They don't even address each other. They talk past each other.
Yeah, which might be one of the problems in life. But we'll leave that for another conversation. Jess, let me ask you this question, which confused me. Chief Justice Roberts said that applicants could still raise race in essays or some other way as a part of their applications, and then universities could still factor that in their decision-making. Do I have that right?
Yes. I mean, this is the guidance that he gave. It's not that you have to ignore race altogether if that is relevant to a particular applicant. The thing that he focused on, and again, he and the 5 other conservatives, was that race cannot be an automatic benefit. All things being equal, you give the benefit to the Black or Hispanic applicant. That is no longer possible. But can an applicant describe in an essay or in an interview why, how being Black or Hispanic or whatever race that might be affected their lives and how it created obstacles or inspired them or has some impact on them individually? That is okay. The Chief Justice wrote that, if it's relevant to the individual applicant, they can raise it, and the universities can consider it like they could consider other things. What the university cannot do is simply say, this one is Black, we're going to put a sticker on that file, and automatically or at least implicitly assume things about that applicant without that person stating them.
Jess Bravin, once again, walking us through this excellently with the Wall Street Journal. Thanks a lot, Jess.
You bet. Thanks, John.
And joining us now is Andrew Brennen. He's a graduate of the University of North Carolina at Chapel Hill, and he testified in a lower court hearing. Andrew, thank you for being with us. First off, what's your reaction to the decision today?
Thanks for having me. It's a pretty disappointing decision. When I was a student at Chapel Hill, the school was 11% Black in a state that was 22% Black. I had grown up my entire life in the South, but the first and second Confederate rallies I ever saw were on campus at UNC. That was the context in which this case was brought and why it was so important that students have their perspectives as part of the record. But today's ruling really threatens diversity efforts on campus and threatens to make higher education institutions less diverse.
And Andrew, was it those rallies that was the proximate cause for you to get involved, the specific rallies, or were there other factors that encouraged you to get involved in this case?
I think when I heard that the organization Students for Fair Admission was suing the university, I thought they were trying to address the fact that there were so few African-American men on campus at UNC. And so when I heard that actually they were suing the university because they thought we were too diverse, well, that just didn't sit well with me or many of my classmates whose experience at UNC more closely characterized racial hostility and racial isolation in the classroom than what the SFFA complaint alleges.
We just talked about how, in his majority opinion, the Chief Justice said that universities can still take race into account if individual applicants bring it up in their applications to college. How do you think that would work out if you were back and applying for college again?
Well, I can actually tell you exactly how it would work out because I did talk about being Black in my college admissions essay. All throughout high school, I was called an Oreo, someone that was Black on the outside and white on the inside, just because I got good grades in school. And those experiences were important for me to reflect in my college admissions essay. What I hope the message is today is to student organizers, to campus advocates, to campus administrators, and to civil rights advocates. We need to be continuing to hold folks accountable for doing the most they can to ensure diversity on our college campuses, and not just for Black and brown students. All students benefit from having diverse campuses on colleges and universities.
What's your opinion of Justice Thomas said that in his concurring opinion that the Constitution is, quote, colorblind and neither knows nor tolerates classes among citizens? What do you make of that?
Well, the truth is the college admissions process can't be colorblind because our society isn't colorblind. I think Justice Sotomayor put it best in her dissent when she pointed out that because of today's decision, the police can consider my race when assessing my suspicion of a crime, but a college admissions officer can't consider my race when assessing my potential to contribute to a college campus. That's the sort of twisted and tortured logic that had to be employed in order to get to today's decision. And it is a step backwards in the fight to ensure diversity on our college campuses and throughout the institutions of our country.
UNC Chapel Hill graduate Andrew Brennen. Thank you so much, Andrew.
Thank you very much.